So this program today is a 2024 update of legal considerations in specialty pharmacy. And our speaker is Jesse Dresser. And we welcome Jesse back to ASHP. This is, I believe, the second time you've been? Possibly third time that he's been able to return to give us these updates. Jesse Dresser is a partner at the boutique healthcare law firm Fryer Levitt, and he's in the pharmacy law group. His focus is on payer issues and litigation, and he also focuses on state laws, pharmacy practices and state laws, insurance, billing, and PBM regulation, among many other things. And I'm the moderator, Joanne Stubbings, and I'm a clinical associate professor emerita at University of Illinois Chicago College of Pharmacy. And this is just a brief introduction to Fryer Levitt. Jesse gave me permission not to read this. And some disclosure: in accordance with the standards of integrity and independence, ASHP is required to disclose relevant financial relationships of anyone in a position to control content. Please note the disclosure slide in this presentation, and we claim no disclosures. So with that, I'd like to pass this on to Jesse and welcome him to ASHP, and thank you all for attending this packed session that we're going to have this morning.
Thank you, Joanne, and thank you for all you brave souls for making it out here at 8 in the morning to spend the next 2 hours with me. I can't believe that anyone wants to spend 2 hours listening to me talk, but should be good. Hopefully it's going to be some pearls of wisdom, some new information. You know, as Joanne mentioned, I've been doing this a couple of years, and each year Joanne's been great about trying to get vignettes and other hot topic issues from the ASHP membership. So what I've endeavored to do is try to update the presentation each year with some of these updates. And one of the things that I'm going to do throughout the presentation is I'm going to give my email address in a minute. So if there are questions that you have or issues that come up while I'm giving my talk, you don't feel like coming up to the microphone or you don't want to forget about it, feel free to shoot me an email. And at the end of the session, I'll try to hit as many of those topics as possible. So, quick show of hands. How many people feel like they are pretty well versed in PBM issues? Okay, I see a couple of these. I don't want to go all the way up. How many people are affiliated with a 340B health system? Okay, so we got two things. So we're gonna do a big overview of PBM issues, just so we kind of lay a good groundwork, and I'm gonna focus on things that are tailored to these types of practices. So, in terms of my agenda, what I endeavor to do for this session, because we have 2 hours, is set it up so we'll have a lecture with some topics, followed by a group workshop where I want to try to foster your thinking on how to apply some of the things that I'm discussing during my lecture to some of the core issues that hospital health system pharmacies face on a regular basis. And as I mentioned, I'm going to do an attendee's choice where ask me anything. Shoot me a note at my email address. If there's anything that comes up during the course of the lecture that you want to double click on, get more information on, or even just follow up afterwards, feel free to shoot me a note. My email is jdresser@fryerlevitt.com. So, first issue is PBM and payer issues. One last question. I've been doing this a couple of years. How many people have been to my sessions before? Okay, so a little under a third. Okay, so new stuff for many folks. For the folks that have been here before, I apologize if this is old stuff. But again, I'm hoping to inject new information as we go along. So I always start with this slide because it's a great visual representation of everyone in the country. This is a pie chart that shows where everyone in the country sits in terms of how they have health insurance, whether they have it through their employer, whether they have it through a government program like Medicare or Medicaid, whether they don't have it at all. So the reason that this is important is when we talk about laws and regulations and rules that apply to payers, it all depends on what type of payer it is. So if you look at the big green section, obviously that's your employer group market. You have the largest chunk, that's the large employer group. Those are typically self-funded, self-insured large employers like your Pepsis, like your Caterpillars, like your Exxon Mobils. And essentially what they're doing is they're not buying insurance on behalf of their employees. They're self-funding. If they pay the claims as they come through. There's no paying premiums on behalf of their employees. They're just saying we have enough employees, we can bear the risk. Now the reason that that's important is even though that's a private commercial plan, it's generally not going to be subject to many state laws because it's going to be governed by ERISA, the Employment Retirement Income Security Act of 1974. That's a federal law that regulates employee benefits. So we move down to that smaller section, the small employer group market. That's more your smaller employers. They are buying insurance plans on behalf of their employees. They're paying premiums. They don't have enough employees to spread the risk around. Those plans are typically governed by state law because states have the ability to regulate the practice of insurance. You next have the public employees. These are folks that work for the state. These are folks that work for state agencies. Again, usually a function of state law because they're essentially public employees of the state. You have the dark green section, that's TRICARE. That's going to be a federal program governed by federal laws and regulations. And then you have the orange section, that is Medicare. Medicare is a federal program, and as a result, it's governed by federal law. So when we talk about throughout this presentation different states' laws, different state requirements, they're generally not going to apply to Medicare Part D plans because it's a federal program. You have Medicaid plans in the red. Those are going to be a combination of both federal and state laws. There's going to be some federal requirements that apply to all Medicaid plans, but some states will also have rules that apply to the Medicaid plans in their own states. And again, it's important to start here because one of the first questions I ask clients when they come in, they're saying they have a problem with an insurance company is, what's the plan? You know, are they a self-funded private company? Are they a Medicaid plan? Are they a Medicare Part D plan? That's going to be the first question. I want you to think about that as you're kind of troubleshooting and documenting problems because this is going to be an important piece of data that you're going to want to make sure that you're gathering as much as possible. So, quick layout on the pharmacy benefit industry, right? So, in terms of the pharmacy benefit landscape, you have plan sponsors. These could be employers, union groups, government programs, and essentially they're sponsoring some form of plan. They are the ultimate financial guarantors of that plan. They're the ones that are either paying the premiums or they're the ones that are paying out the claims and responsible for paying out the claims. In turn, there's health insurance companies, and those plan sponsors can contract with health insurance companies either on an administrative services only basis or group health insurance basis. So, small employer, they're going to be buying insurance and contracting with an insurance company on a group health insurance basis. If you have a large employer like Pepsi, for example, they may still contract with an insurance company, but not for purposes of buying insurance on behalf of their employees, but rather having the insurance company process claims. It doesn't make sense for Pepsi's not in the business of processing health insurance claims. They'll contract with an entity that is, and that's where they do it on an administrative services only basis. In turn, either through the health insurance companies or the plan sponsor directly will contract with PBMs to handle the pharmacy benefits. So the health insurance company handles the medical benefit. You go to the doctor, you go to the lab, you go to the hospital, covered under the medical benefit. The pharmacy benefit is covering the drug spend. In turn, PBMs contract with a network of retail and specialty pharmacies. And importantly, PBMs also own their own mail order and specialty pharmacies. And this is important because they're not only the gatekeeper of who gets in the network or what the reimbursement rates are, but they're also a direct competitor of you. They also have a vested interest in trying to get the business to themselves because these are all for-profit companies, which I'll get into in a minute. PBMs negotiate with manufacturers for rebates in exchange for formulary placement, who then in turn sell products to pharmacies through wholesalers. And at the end of the day, PBM-owned specialty pharmacies and independent pharmacies compete to provide services to patients who in turn are beneficiaries or dependents or employees of the plan sponsors. So at a glance, this is what the state of the industry looks like right now, where you have such a level of consolidation, such a level of vertical integration that it's hard to separate the different stakeholders, particularly on the PBM landscape. So you have Express Scripts, Caremark, and Optum. Those three PBMs make up more than 85% of the marketplace in terms of covered lives. That's three payers across the country that control such a dominant percentage of lives. We're basically dealing with these three. Now there are a couple others. They're depending on your region, you may face a higher percentage of Humana patients or higher percentage of Prime Therapeutics patients. But you can see that even that aside, there's still a great deal of consolidation and collaboration even among the different PBMs. So if you look from the top to the bottom, you have the plan sponsors. These are the large insurance groups. All the PBMs are either owned or own large insurance companies. Aetna is owned by CVS Caremark. Cigna owns Express Scripts. UnitedHealth owns Optum. Humana is integrated, as well as Prime Therapeutics is wholly owned by a consortium of 26 different blue plans. In addition to PBMs, there's another layer that I think a lot of people don't recognize, and this is rebate aggregators. These are sometimes referred to as rebate GPOs, and essentially what they're doing is they're creating another intermediary between the manufacturer and the PBM to negotiate rebates. And what you can see is there are three main rebate aggregators: Zinc, Ascent, and MSR. 2 out of the 3 are not based in the United States. Now, why is there a company based in another country to negotiate rebates for United States drug claims? One argument might be that it's endeavoring to create some level of shield or hiding the ball, so to speak, when it comes to the rebates that are actually received. But you can also see that some of the other independent PBMs still leverage the rebate aggregators that are owned or affiliated with some of the other PBMs. Now, this is where it also gets important too, because if you look at the bottom 2 tiers, you'll see that in addition to being PBMs and health insurance companies and rebate aggregators, these companies also own and operate their own specialty pharmacies, in some instances retail pharmacies, and a growing number of these companies are also seeking to operate their own providers, their own direct providers, whether they be doctors, whether they be urgent care centers, whether they be other types of traditional healthcare providers. So again, it's important to kind of keep this in mind for a variety of reasons. One, to recognize the unique incentives that PBMs have, and 2, to recognize the unique opportunities that you may have to leverage this landscape when you're making your case, when you're arguing that you need access to the network, or you're arguing that a certain activity that the PBMs are engaging in is unfair or violates the law. So one of the things that I also try to do with this lecture is I try to take things that people have, that when I have more than one pharmacy come to me with the same issue, I gotta figure it's a trend. I gotta figure that there are more people facing similar things. So what I've tried to do with this is layer in real stories that I've heard not once, not twice, three or more times from clients on issues that they're facing. So here's an example. Pharmacy receives rejected claims for certain specialty drugs and is told by the PBM it must be participating in the specialty network to fill those prescriptions. The pharmacy requests the application and is given 30 days to submit the application. Pharmacy applies to the specialty network and is denied admission, being told it does not meet the terms and conditions for participation and that it has to wait an additional year to reapply. After the year has passed, the pharmacy reapplies. After passing the initial application phase, it's denied on the basis that it does not meet unreasonable prescription volume requirements, such as 10,000 prescriptions a day, licensure requirements such that it's licensed in all 50 states, it doesn't have triple accreditation, and doesn't have access to all limited distribution drugs in all therapeutic categories. Again, the pharmacy is told it has to wait a year to reapply. Raise your hand if that sounds familiar. So this is a very, very common issue that we've seen with a lot of PBMs. Now the question is why? Why is it that we have state-of-the-art, top of the line medical centers and health systems and pharmacies that are being told time and time again that they can't get into a particular network. All I got to do is go back to the last slide. You have these PBMs that have their wholly owned specialty pharmacies. They want to create artificial barriers of entry. They want to direct people to their wholly owned specialty pharmacies, and they want to create a framework to exclude independent providers. So we'll use this to jump into a discussion about specialty pharmacy networks. And there are specialty pharmacy networks, and they do vary plan to plan, payer to payer. So there's three basic types of specialty pharmacy networks. The first is a closed or exclusive specialty pharmacy network. These are ones where if you ask the PBM, can I get an application, they'll say, it's a closed network. There is no application. We're not accepting applicants at this time. Or they may even say there is no network. You say, well, then how come I'm being told that I have to send it to CVS Specialty Pharmacy? Oh, that's not a network. It's just that that's the pharmacy that our plan sponsor has chosen to be the exclusive specialty pharmacy provider. In these instances, we typically see them in commercial self-funded plans. Again, if we go back to that earlier slide with the pie chart, those are those large employer groups that are not subject to state law, that are governed by ERISA. You then have what I would refer to as open specialty pharmacy networks, but with heightened admission criteria. That might be that scenario we just discussed, the sounds familiar scenario, where you'll see it in commercial plans in states that have some form of an any willing provider law requirement, and the PBM is endeavoring to create a nominal opportunity for the pharmacy to apply and to participate on terms and conditions, but they're not actually meaningful terms and conditions. They're heightened barriers of entry and designed to keep people out. The third is open specialty pharmacy networks, truly open specialty pharmacy networks. We typically see these in Medicare Part D. Why? Because there is a pretty robust set of rules around the requirements that PBMs let pharmacies into those networks. In terms of the specialty pharmacy credentialing requirements, these are some common ones that we've seen. Accreditation is a big one. We typically see a requirement that you have two forms of accreditation. Usually what we've seen is URAC plus either ACHC or the Joint Commission. One of the challenges that I oftentimes see with these multiple accreditation requirements is that sometimes your accreditation standards for one accrediting body may be in somewhat conflict with your accreditation requirements for another accrediting body. And you have to be really careful about structuring your policies and procedures and your operations so that you're not kind of running afoul of both. But again, it goes to the idea of whether or not even that requirement is a reasonable term and condition. Another concept is higher insurance coverage. Instead of having, 1 million per occurrence, 3 million in the aggregate, they may look for 5 million per occurrence, 10 million in the aggregate. They may look for certain types of cyber liability insurance, other forms of additional levels of coverage that go beyond what's typically required under other contracts. Detailed policies and procedures is another concept that they will want to see, including disease state-specific policies and procedures. How are you handling MS patients? How are you handling Hep C patients? Shipping and tracking controls is another key one, along with mechanical systems and tools. Another common example is proof of access to limited distribution drugs. These are products that the manufacturer has created a smaller panel of providers that they're willing to give access to, and PBMs know that not everyone can get access to these drugs, and they'll use that as a basis to try to limit the amount of people in the network if you don't have access to those limited distribution drugs. Detailed reporting requirements and capabilities. This is a big one too, where we've seen a lot of specialty pharmacy applications will want to see your reports on your percentage of days covered, your call answering speeds, your utilization reports, a variety of different reporting that has to be done on a monthly basis. And it requires management. It requires someone that's dedicated to collecting the data for the reports, gathering them, and providing them without being prompted, without being asked, because they're not going to give you a stink if you don't provide it. But then all of a sudden you'll get a termination letter that says you haven't provided the reports for the past 3 quarters, and so you're being terminated from this network. So it's important that you have systems in place to gather this information and to proactively report it. FDA recall procedures, patient utilization tracking and monitoring of in-home inventories, 50-state licensure. This is another big one where, even if you're only looking to service your own state, a lot of PBMs are still requiring and still wanting to see that you're licensed in all 50 states in order to come into the network. Nursing services is another one, and call answering speed requirements is another one. So how do the different PBMs handle specialty pharmacy credentialing? CVS Caremark, they've kind of taken a unique approach where their contract doesn't say that you can't do specialty. Their standard retail agreement doesn't say that you can't do specialty, but what you're going to find is you're going to have some plans that'll come back and say, product service not covered or pharmacy not contracted must go to CVS Specialty Pharmacy or must go to a designated in-network specialty pharmacy. In those instances, the way that they've typically done it is they'll create a specialty pharmacy network or application process on a plan-by-plan basis. And so if you say, I'd like to get into the specialty network, their first question is, which one? Which plan? And so that's why, again, it's important to recognize who the plan sponsor is and track that information, because that's going to come into play when you're trying to figure out which application you're going to want to get. Within their application, they're asking for detailed policies. They're asking for detailed reports on an ongoing basis. They're asking a lot of background-related questions. Have you ever been terminated by a PBM? Have you ever had bad audit results in the past 5 years? A variety of questions like that. OptumRx is very similar to that that sounds familiar scenario that I discussed. They have a process where it's kind of a two-tiered approach. They'll send you a questionnaire to help identify your specialty drug volume by drug or by therapeutic class. And then if they determine that you have enough volume in their own metric and their own criteria that they won't tell you about, they'll give you an application to fill out. That application may require a binder this thick of information that they want to see, and then they're going to score you. And I think you need an 85% or higher score in order to come in. And it's very Byzantine as to how they come up with what you've scored. You send in all this information, you think you've done pretty good, you're dual accredited, you have sophisticated people that work with you, and you come back and they say you got a 56, and they don't really give you much in the way of how they came up with that number. Humana has an application that they will offer a mail order specialty network. Some of the key things that we've seen in that network is they want to see 50-state licensure, they want to see nursing. They do have requirements in terms of prescription volume capabilities, but that's been one that we haven't seen as draconianly enforced. It's a little bit of a draconian requirement that we just haven't seen them be too heavy on. With Express Scripts, it almost seems like a money grab in terms of their specialty application. They want fees to submit it. They want fees to conduct the on-site visit. They want fees to have the follow-ups. And at the end of the day, they're pushing people that have more than 50% of their AWP as specialty drugs into those specialty networks. And then Pharm, because it manages the plans on behalf of a lot of blue plans, even though it's a national PBM, they typically handle their specialty credentialing on a plan-by-plan basis. Usually it's tied to that particular blue plan. So if you're looking to try to get into a specialty network, it's important to understand which blue plan is the one that you're kind of focused on. So another concept that's kind of related to specialty is the concept of mailing. The idea that you are dispensing a drug and then shipping it or delivering it to the patient in some way, shape, or form. And because most PBM contracts are built around a retail pharmacy business model, and most of the ones that they will give you, at least to start, are a retail pharmacy contract, they typically have language that precludes mailing, that prohibits mailing in some form. So several PBMs, including Optum and Humana, explicitly prohibit mailing under their manuals. Others, like CVS and Express Scripts, suggest that pharmacies are liable to receive separate contracts if they mail more than a certain percentage of claims. For example, CVS says if you mail more than 20% of your claims, you're liable to receive a different contract. You're not a retail pharmacy and you're liable to receive a different contract. Some PBMs nominally offer participation in mail order networks, but set terms and conditions extremely high. Humana is one of them, Optum is one of them, where they will allow you to apply for participation in a mail order network, but they'll set very, very high terms and conditions for application. A lot of the PBMs during the public health emergency, during COVID, they relaxed these mailing prohibitions for obvious reasons. They were directed to, the patients needed the medication, and so they relaxed their enforcement of these requirements. Now, a lot of people will say that the entire world has changed since COVID, that the idea of retail in general has changed. You know, it's common to no longer expect to have to go to any store to get anything. You know, whether it's flowers, whether it's groceries, whether it's beauty products, whether it's your clothes. The idea that even though there's a brick and mortar, you may never go to it. So the idea that now that the public health emergency ended in May of last year, that now all of a sudden they're going to prohibit you from mailing or limit you from mailing is kind of flies in the face of the way things stand today. Nevertheless, since the lifting of the public health emergency, Optum and Humana, for example, have begun trying to reassert their enforcement of the mailing prohibitions. These have included cease and desist letters. These have included network terminations. These have included audits and recoupments over claims that were mailed under a retail network. And again, these are things that if you face some of them, if you get one of these letters, if you get one of these audit recoupments, it's important to recognize that there are rights available. We'll get into what some of those look like, but there are rights available, there are strategies available, there are some tools available. So before I shift gears into reimbursement issues, does anyone have any questions? You know, if you have questions, I'd love to take them along the way, and as opposed to wait until the end until everyone forgets about it. But if you have a question, just raise your hand and we'll come up to the microphone. All right, so shifting gears to reimbursement issues. So one of the things that I want to just kind of lay a good groundwork with is the different ways that drugs are reimbursed. There are a lot of different pricing methodologies out there. It can feel a little bit like an alphabet soup. I won't get into all of these now because I'll touch on them in a little bit, but there are a variety of different mechanisms that are used, and it's important to understand what those mechanisms are and know how to look at them, how to track them, how they're measured, because that's going to help translate into what your strategies are if you're facing reimbursement issues. So in the pharmacy benefit space, the most common form of reimbursement is based off of AWP, average wholesale price. And typically PBM contracts say we're going to pay you an AWP discount. We're going to pay you AWP minus 18%. We're going to pay you AWP minus 20%. AWP is akin to MSRP. It's akin to a suggested price reported by the drug manufacturers on what they think it should retail for, and PBMs will in turn say we're going to pay a discount off of that benchmark price. On the flip side, you have ASP. ASP is what's typically seen on medical benefit contracts. So if you're in Medicare Part B as in boy space, or you're in certain home infusion or medical benefit contracts, that's typically what we're seeing is ASP. ASP, unlike AWP, is regulated by law. There's a statutory formula that manufacturers have to follow in setting ASP, and under Medicare, that's where we see ASP plus 6% because it's literally an average sales price of what's out there in the marketplace. A couple other things to kind of take note of: wholesale acquisition cost. That is supposed to be tied a little bit more to what the actual prices are that the product is sold at wholesale. Usual and customer, UNC, that's the amount that a pharmacy will sell to a cash-paying patient without insurance, inclusive of all discounts, loss leaders, special customer discounts, etc. When PBMs reimburse a pharmacy, they're going to use what I call the beauty contest, the lesser of methodology. And it's going to be the lesser of the AWP discount plus a dispensing fee, or the MAC price plus a dispensing fee, or the pharmacy's submitted usual and customary price, or otherwise set forth in a rate schedule. And within NCPDP, the standardized set of data that gets transmitted at the point of sale by the pharmacy through their pharmacy management software system, there are certain fields that tell the PBM how you are seeking reimbursement for that drug, whether you're seeking reimbursement based off of a usual and customary price, whether you're seeking reimbursement based on a 340B price, whether you're seeking reimbursement based off of your AWP discount. At the same time, there is a process that the PBM, when they adjudicate the claim and they push it back to you, that tells you how they ultimately paid you. So if you submitted at your full AWP, which let's say is 10% higher than the AWP for the drug, you submitted at your full usual and customary cost, which is let's say 10% higher than the AWP, you might get a price back and it's much lower than both of those, and you scratch your head trying to figure out how the PBM arrived at that number. Well, that data is going to be in that NCPDP claims response. It's going to say, we paid you based off of this metric. It could be MAC, it could be AWP discount, it could be federal upper limit, it could be a variety of different things. It's important to track that information, understand it, because it's going to convert into how you're going to try to enforce your agreement or what other rights you might have under the law. So, another sound familiar situation. Health system expected retrospective DIR fees to end as of January 1st, 2024, and for reimbursement rates to improve. But in looking at 2024 claims reimbursement, the health system realizes that it's receiving decreased upfront reimbursement rates at the point of sale. The decreased point of sale reimbursement rate is lower than the net amounts that it was receiving after the application of DIR fees in 2023. Worst of all, the health system's reimbursement rates are below the acquisition cost of the drug or don't cover the cost of dispensing. Again, anyone experience this, and it sound familiar to anyone? Yeah, this is something I've even heard a couple times since being at this conference today. This is a symptom of what I call the DIR fee hangover. So DIR fees as of January 1st, 2024 could no longer be assessed on claims that were processed after January 1st, 2024. Essentially what had happened is CMS put out a rule that said the negotiated price, the price that the patient pays a copay off of the price that is used for calculating catastrophic coverage, that price has to be the lowest possible price that there is, inclusive of all potential DIR fees. Didn't say the PBMs couldn't assess DIR fees. The PBMs still could assess DIR fees if they wanted. It just removed the financial incentive for PBMs to assess DIR fees, because now, whereas before, if they assessed DIR fees, they didn't have to pay back that money to Medicare. They were able to use that as a special discount to themselves where they got that money, but now that this rule has gone into effect, they would have to true up that money to Medicare. So it just doesn't make financial sense for them to do it anymore. So as a result, all the PBMs have essentially gotten in line and stopped it as of January 1st, 2024. However, many PBMs assess DIR fees retrospectively. And so what that means is certainly for the first couple months of 2024, and even continuing now for some PBMs, they're still recouping DIR fees for claims that were dispensed and assessed in 2023. And so now you're getting the double dip. You're getting the lower upfront reimbursement rate that the PBMs have done to kind of account for the fact that DIR fees no longer exist, plus the recoupment from DIR from 2023. Caremark's is probably the last one to be working its way through. It should be done by about the end of August, because there's still, the way that they do it is you have your claims period, then there's a measurement period, then there's a recoupment period. And the recoupment period is supposed to continue through August. So after August, you should stop seeing any form of DIR fees coming back from Caremark, because it would have passed. One of the other things that I've advised a lot of clients on is calculating their apples to apples comparison between the 2023 rates and the 2024 rates. Because again, we're accounting for a lower point of sale reimbursement rate than maybe you got in 2023, but there's no DIR fees. And the question is, how does it actually shake up? And you really want to look ideally at the same plan, same PBM, same Part D plan, same drug, and try to get a sense of what that apples to apples comparison is. Because again, knowing what you're actually being reimbursed is incredibly important for a variety of reasons. It's going to dictate whether you want to stay in that network. It's going to dictate whether that network is offering reasonable terms and conditions. It's going to dictate whether there may be a claim to be brought under some of these laws that apply to reimbursement rates. So important to be tracking that information. Another issue that we've seen as a result of the sunsetting of DIR fees is net reimbursement rates have gone down. So even when you take away the DIR fees, you do that comparison of apples to apples, the net you're down at least a couple basis points, if not maybe a percentage point or two. So we have seen some health systems report decrease in overall reimbursement by more than 15%, and this is common not just in the hospital health system specialty pharmacy space, but even in other segments as well. Express Scripts has been particularly bad. We've seen contracts that have year-over-year rate degradation. So that means that your reimbursement rate this year might be AWP minus 20. Your reimbursement rate, because it's a 3-year contract, your reimbursement rate next year is going to be AWP minus 21. And then in year 3, it's going to be AWP minus 22. So every year you're seeing your reimbursement rates go down and down and down. And then what that means is if you're going to sign an agreement like that, you need to be in a position where you know that with your suppliers, you're going to be able to drive that corresponding savings. Otherwise, you're going to find yourself underwater pretty quick. Another concept that we've seen is up to an average aggregate discount, network discount of AWP minus. This is Express Scripts essentially saying we're going to pay you up to an average aggregate discount of, let's say, AWP minus 26%. That doesn't mean that on every single claim for you, you're going to get that rate. It doesn't even mean that your average is going to be that rate. It means the whole network's average is going to be that rate. So they could theoretically pay their own pharmacy full AWP, and they could pay you AWP minus 50, and if you average the two together, they've theoretically met their contractual terms and conditions. I'll get into that a little bit more on that in a minute. The biggest thing that we've seen in terms of the explosion of the impact that this has had on a lot of providers is, in addition to now Express Scripts having such worse reimbursement rates, as of the beginning of this year, a couple large Medicaid plans migrated from CVS to Express Scripts. WellCare, Fidelis, Centene, they moved from CVS to Express Scripts. And so these were pretty big Part D plans that a lot of people had volume in. They were volume through CVS Caremark, but now they're volume through Express Scripts and volume at that much, much lower rate. So that's another area where we've seen a lot of kind of, whoa, what's happening with reimbursement rates this year kind of come into play. So, as I mentioned, and this is a snippet of a publicly available version of a ESI contract, and as you can see, it's got language that says up to an average aggregate discount for single source brands of AWP minus 26.3. One of the things that we've worked with a lot of providers on is to think about it in terms of your cost of goods sold and what that looks like at WAC. And here's a chart that shows you basically where your break even is under AWP minus 26.3% off of WAC. So if you're buying at WAC minus 2%, and you get a contract that's AWP minus 26.3, you're being reimbursed almost 10% below your costs. You need to be reimbursed at least AWP minus 18.33% in order for you to even break even at WAC minus 2. Now, maybe you're buying better than WAC minus 2, but it's this type of study that you should be doing to figure out what the break even points are on these contracts. And the other reason that I'll say that these studies are important is a lot of people get these contracts from PBMs and they sign them. They're afraid of losing the contract and they just sign them. They don't really think about it. They don't have a dedicated process to kind of receive them, review them, contemplate them. negotiate them. We've had a lot of clients that have successfully gone back to the PBMs and said, hey, these rates aren't going to work. We need to do something here. These rates are not going to work. We need to have some level of negotiation. And the PBM is going to say, why? We think that the rates are reasonable. Now enter your data. You need to be able to show that they're not reasonable. You need to show that the rates are the acquisition costs aren't available. You need to show that there's harm to your 340B program. You need to be able to have some of this data to go back to them to be able to push back. A related concept to this is the concept of generic effective rate and brand effective rate. These are instances where, again, the payer is setting an average aggregate network discount on generics or brands, and we've seen it where it's measured either on a network level or on a pharmacy level. Show of hands, how many people are in a PSAO, Pharmacy Services Administrative Organization, like MHA or Health Mart Atlas? Okay, so a lot of times GER and BER will be measured on that PSAO network level. So all the Health Mart Atlas pharmacies will be measured together. All the Elevate pharmacies will be measured together. Sometimes it's measured across the entire book of business from the PBM. Sometimes it's measured just on one particular pharmacy's basis. A lot of contracts will say we're going to pay multi-source generics at a MAC price, and we're going to target a particular generic effective rate guarantee, for example, AWP minus 85%. So generics that aren't multi-source are reimbursed at a default rate, let's say AWP minus 25%. But multi-source generics that do not have a steep discount are MAC'd at rates high enough to, and in addition, multi-source generics that don't have steep discounts are MAC'd at rates high enough to cover the acquisition cost, even if the discount is lower than the GER guarantee, like AWP minus 50%. So what does that mean? That means if you're dispensing drugs that are either single source generics and therefore you're getting the default generic rate, or you're dispensing a lot of drugs that maybe for the economics for that particular generic, the max discount that you're able to get is AWP minus 50%. You're not able to get up to that AWP minus 85% guarantee. It means that at the end of the measurement period, they're going to reconcile to make everything an average of AWP minus 85%. So how does that look? What does that look like? So let's say you have these four drugs and they're setting a MAC price. You have drug 1, that's $11, drug 2, that's $13, drug 3, $16, drug 4 is $21, drug 5 is $25. Okay? So if the PBM establishes a MAC price of $19, that means that effectively they're going to drive you to purchase and dispense drugs 1, 2, and 3. It wouldn't make sense to buy and dispense drugs 4 and 5 because you're going to be underwater based on the PBM's MAC price. And if you bought and dispensed drug 5, and even if you submitted a MAC appeal and said, it cost me $25, I can't be paid $19, the PBM's going to turn around and they're going to say, go buy drug 1, 2, or 3 because they're at or below the MAC price. So acquisition price is one thing. AWP is another. So if you look at those same products, and let's say drug 1 has an AWP of AWP minus 88, drug 2 has AWP minus 86, drug 3 has AWP minus 84, drug 4 has AWP minus 80, and drug 5 has AWP minus 78. If the GER is 87%, let's say, and you filled too much of drugs 2 and 3, even though we go back to that other slide, they were at or below the MAC price, you would have been above water, you would have been in the black by dispensing it at that MAC price. If you filled too many of those prescriptions, you're at risk of a GER true-up because they didn't average the generic effective rate of AWP minus 87%. So how does that translate in the specialty space? In the specialty space, we're dealing a lot with brands. We're dealing a lot with some single-source generics. We're not dealing a ton with just multi-source generics. These are, a lot of times, they are complex therapies. They're innovative products. They aren't things that have a lot of different options out there. So these are two kind of generic drug mixes that you might see at a normal corner store retail pharmacy versus a specialty pharmacy that has only a handful of generic drugs that they're dispensing. So for a regular retail pharmacy, their break-even point might be here, meaning everything to the left of them, they are losing money on them, but everything to the right, they're making money. So they're losing money on a small percentage of claims, they're breaking even on the majority of their claims, and they're even making some extra profits on some of their claims. Compare that with a specialty drug mix, right? Their break-even point might be here on their distribution chart. So that means that everything to the left, they're losing money, and so the majority of their claims, they're actually losing money. They may lose a significant amount of money on some of their claims, but the profits on the rest of their claims, the ones that are in the black, aren't going to be sufficient to, on the overall, make it so that it's profitable for that pharmacy. So here in if you look at that generic effective rate of AWP minus 85%, overall for a regular retail pharmacy, their overall profit percentage might be reasonable. But if you look at a specialty pharmacy that's being applied that same generic effective rate guarantee, they may be operating at a net loss over the course of the year. So again, tracking this is important because if you can establish that at the end of the year you're trending in the red, you're at or below your acquisition costs across all drugs, even if you include the handful of drugs that you're making outsized profits on. If at the end of the year you're for this particular plan you're trending at or below acquisition costs, again, that suggests that it's not a reasonable term and condition and could be actionable. So even though DIR fees went away, they still remain a big area of focus retrospectively for a lot of health system pharmacy clients of mine. I have a lot of health system pharmacy clients that are looking at years past, looking at the DIR fees that we're taking back, looking at the impact that it's had. So I just spent a couple minutes just talking about some of the programs that were in place. So CVS Caremark, they used a performance score program to assess DIR fees. We have found that their performance score methodology was flawed for a variety of reasons. So it would calculate using metrics where pharmacies had zero claims. So for example, if you didn't dispense statins or diabetes medications or ACE inhibitors, they would just give you an average score. Regardless of how well you would have done or how well you did in other therapeutic classes, if you didn't have volume in those categories, they just give you a network average score. And so it could have nothing to do with you, and now all of a sudden you're having potentially millions of dollars of DIR fees clawed back on something you had no control over. We've also seen them use medication possession ratio, or MPR, that doesn't take into account certain events that could lead to cessation or pausing of therapy. For example, there are certain drugs that require or direct, even on their labels, for the prescriber and the pharmacy to stop therapy if certain lab values are hit or certain toxicity levels are hit. For example, the drug Stivarga is a good example where the label literally says stop therapy if toxicity levels reach a certain level. And because the programs don't take that into account, you could be penalized for not dispensing that drug to that patient under that circumstance, and again, translate into potentially millions of dollars of DIR fees, because even a couple of basis points difference between your score from, let's say a 3% DIR fee to a 3.5% DIR fee could be, over the course of the year, over all your volume, could be a pretty significant amount of money. Humana, they recouped DIR fees, about a 10% DIR fee on all Medicare Part D claims. In the specialty context, they measured adherence for HIV, MS, and Hep C products. And again, if providers don't have sufficient volume in those categories, they're given an average score and just having had DIR fees taken out without any meaningful opportunity to impact them. Express Scripts has, they used last year, and they were continuing to use a bonus pool program. So essentially they said, we are going to collect about 75 cents a claim from all pharmacies on all claims that's going to go into a bonus pool. That bonus pool is then going to be used to pay bonuses to pharmacies that perform well based on certain metrics. Again, as you can see, none of the metrics have much to do with things that are capable of being impacted by specialty pharmacies. We have contended and had contended that these fees violated the program rules around DIR fee reporting, that they weren't being reported in the way that CMS's January 1st, your CMS's final rule that took effect January 1st, 2024, we believed that they were not being reported appropriately. Because they were, a dollar or less, they were a little bit less impactful in the specialty pharmacy space, but they were extremely impactful for the community pharmacy space. If you're dispensing a $1.50 generic and they're taking a dollar back, it's a huge problem. Literally, as of Monday, yesterday, Express Scripts just came out with a notice that pushed out to membership that said, even though we don't think that they were a problem, based on discussions with CMS, we are stopping the bonus pool program. We are going to refund the fees that were collected. We are going to pass them back and stop doing it. But again, we don't think we did anything wrong. We're just doing it, right? This literally happened yesterday. This is what it looked like when you got your remittance reports. You would see line items like this that would have a deduction off of ingredient cost paid associated with these bonus fees. So what I would encourage everyone to do is take a look at them. It's not going to be millions of dollars, but it could be a couple $1,000s. Look at them, make sure you're getting that money back, because again, it's been one of those things that Express Scripts has come and done a little bit of an about face on and should be giving money back on. Another area that is a big area of focus for a lot of my clients in the DIR space is 340B. There's a strong argument that DIR fees should not be assessed on 340B claims for a variety of reasons. We have seen contracts that involve certain payers and Part D plans that create carve-outs for 340B claims, and so if you have 340B revenue and 340B revenue through Part D plans and you paid DIR fees on it, essentially the PBMs were siphoning off your 340B savings to provide 340B enabled care and delivering that savings to their Part D plan sponsors. So we think that there's a strong case that can be made, in addition to all those other arguments that we talked about the metrics being inapplicable, about the rates being unfair. If you're paying DIR fees on 340B claims, that's potentially actionable in and of itself. So one of the most common things that people ask me when we talk about DIR fees, when we talk about the problems, when we talk about the impact that it's had is, have you had any success? What have providers been able to do? And one of the challenges is a lot of these cases are private arbitrations. They are confidential private arbitrations that aren't in court. They're not public. They're hard to talk about because of confidentiality requirements. Fortunately, though, we have a couple of unsealed victories that have gone through an arbitration or gone through a trial. They have gone to court. While in court to confirm that award, they've been unsealed, so now they're public, and now I can talk about it without being worried about being sued by the PBM. So a couple of recent cases. We had, as you can see, we've had a couple cases where we've obtained multiple $1 million awards on behalf of providers, including attorney's fees, and in some instances, prejudgment interest. We have one case right now where prejudgment interest is, because of the way interest rates are right now, it's literally accruing at $5,000 a day. So if the PBM wants to take its sweet time to pay, we're okay, because it's being accruing interest at $5,000 a day. What's important is that these successes occurred notwithstanding many efforts by PBMs to limit the ability for providers to bring cases. So one of the things that we've seen is mandatory arbitration. This means instead of being able to go to court and pay, $500 filing fee and start a litigation and go through that process, you have to go to private arbitration. That arbitration has an arbitrator who is paid based on the hour. They're paid just like a lawyer. They're paid at an hourly rate. Some PBMs have even said you have to have more than one arbitrator. Sometimes it says you have to have a panel of 3 arbitrators. That's 3 times the fees. Again, it's designed to disincentivize people from asserting their rights and bringing claims. We've also seen things like fee shifting provisions, discovery limitations, contractual efforts to limit damages. By and large, we've been able to to overcome these challenges. We've been able to get around some of the things like 6-month statute of limitations, like discovery limitations, like some of these other things. Why? Because you have these $100 billion companies writing these take it or leave it contracts of adhesion that simply aren't fundamentally fair. There's not a meaningful ability for anyone to have any ability to change the terms or even attempt to negotiate some of these terms. And as a result, we've had courts say that's not fairness, that's not equity, it's unconscionable is the term that gets used. It's unconscionable to include some of these provisions, and we've been able to get around them. Another thing that we have had a lot of people raise with us is, okay, so I sue the PBM or I take action against the PBM, they're just going to kick me out of the network. They're going to retaliate against me. And fortunately, there's pretty strong law, not only at a federal level, but also at a number of state levels that prohibit retaliatory conduct, that prohibit things like a PBM taking action when you try to assert some of your rights under the law. And in fact, we've had recent examples where we got injunctions against a PBM that was trying to terminate a couple of our providers over bringing an action, where we got the injunction that prohibited the PBM from doing that type of conduct. So even though there's a fear of retaliation, one, we just haven't seen it as much as I think a lot of people are afraid that it's going to happen, and two, there are some strong laws that protect against it. I'm just going to do a couple excerpts from a recent arbitrator's opinion on DIR fees. And as you can see, the arbitrator, this is pulled straight from the arbitrator's final finding during the hearing. It is public now because it's been brought in a motion to confirm before a federal court and unsealed. Essentially, the arbitrator found that Caremark's actions were in bad faith or reckless indifference, that their NPR methodologies with respect to oncology medications, that they misrepresented the contractual terms, knowing full well that Caremark would not fulfill those contractual promises, that Caremark took advantage of oncology providers' ignorance regarding how NPR would be measured, and Caremark mechanically penalized oncology providers' choice of oncology medications without allowing for provider-informed judgment to discontinue therapy, and the evidence presented demonstrates that this approach to NPR was seriously and willfully misguided. So you have a finding now that's public. It may not be binding, but it's at least precedential for future cases on how these programs are viewed, that they're literally viewed with bad faith and reckless indifference. So we talked about before some of the strategies. So these are it's all well and good to understand what's going on, to get some of the industry, kind of updates on it, but a lot of the question that I get a lot after this is, what can I do? What can I do on a daily basis that's going to help deal with this? And so here are some strategies to deal with below water reimbursement rates. So one, keep track of any prescriptions that you are sending out to other providers to fill. Keep track of all the claims data, the BIN, PCN, group number, the patient information, the plan if you know it, the patient's employer if you know it. Keep track of what pharmacies they're going to. Try to follow that patient's journey. Try to figure out what happened to that patient. Did the patient get the medication? Did they have an adverse reaction? Did they fall off therapy? What happened? Create those stories, those case studies. Consider state law claims, especially for commercial reimbursement, as some states prohibit below acquisition cost reimbursements and provide unique appeals processes. Maximum allowable cost appeal laws are something that a lot of states have put out. Federal law, if it's a Medicare Part D plan, prohibit unreasonably low reimbursement rates for all Medicare Part D drugs. And literally, this is the quote from the CMS manual. Offering pharmacies unreasonably low reimbursement rates for certain specialty drugs may not be used to subvert the convenient access standards. In other words, Part D sponsors must offer reasonable and relevant reimbursement for all Part D drugs as required by the Medicare Any Willing Provider Law. Utilize the dispute resolution process in each PBM or payer contract to initiate disputes, including binding arbitration and/or litigation. There's also the importance of filing complaints with regulatory agencies. We have had many discussions with lawmakers, many discussions with agencies, and say we just don't see the complaints. We don't see there being a problem. There's just not complaints. You need to have the complaints if you're going to see action. There needs to be a record, and particularly you see a couple bullet points down, you need to be able to establish that there's a requirement for agency action and a failure of that agency to take action. And you can't establish that unless you can show that there's a history of complaints being made and them not doing anything. One thing that CMS did do recently is they put out a notice, a little tepid of a first step, but they did say in December 2023, they letter to PBMs and plan sponsors that they'd received communications that they were concerned that the actions by PBMs and plan sponsors was not enough, particularly in the wake of the sunsetting of DIR fees to account for reasonable reimbursement rates. But again, it's not sufficient. A lot of people will say, CMS is going to fix everything. CMS is going to fix everything. The fact of the matter is that unless there is some significant levels of complaints, provider complaints, it's not going to happen. And even then, it's not something that I would put money on. It's not something I would rely on. I would make sure that you're still covering those bases through a multi-pronged approach, but not something that you're standing by and waiting and hoping for. In addition to CMS, I'd also note that there are many states that are conducting their own legislative investigations into PBMs and passing PBM legislation. There's also an investigation pending with the Federal Trade Commission, the FTC. These types of issues, report them to the FTC. There's a channel for that. I would make sure that gets there, because again, if they're going to take action, they need the data, they need the history. So before I get into alternate payment models, does anyone have any questions on reimbursement rate issues? Okie dokie. So just spend a couple minutes on some of these alternate payment models. One of the things that came up is the advent of cost-plus PBM models. These are frameworks where the PBMs supposedly are not doing spread pricing. They're supposedly not keeping any of the rebates. They're supposedly being totally passed through on costs to the providers, and the plans are literally just paying an administrative fee. Capital Rex is probably the biggest proponent of this. That's what their model is based off of, and they think that they're going to be able to compete because their technology costs are so much lower than what the other PBMs have done. So some of the other PBMs have created some of these other networks in terms of, for example, Express Scripts has the Clear network, CVS has this True Cost network, Optum has a Clear Trend Guarantee. A lot of this is just kind of optics, in my opinion. A lot of this is just kind of PR from the PBMs trying to react to the industry a little bit and try to think about other models. There are some challenges to providers associated with this. One issue is the opt-out process. It's not totally clear when you get these contracts whether you even have an ability to opt out or what that process looks like. Sometimes the contract goes to a random fax number, and so if you're not actively monitoring how you're getting communications from PBMs, you're going to miss things like this, or you're going to miss deadlines or windows, or they're going to go to a dead email that no one's checking. There's also issues around brand versus generics. If you have a heavy brand drug mix, you might be profitable compared to if you are only dispensing a high level of generics, you might be underwater based on some of these new methodologies. There's another issue with NADAC. How many people in the last couple of weeks saw a massive drop in NADAC reimbursement? Okay, so I'm a little surprised because I see one hand. Okay, so I've had a lot of clients come to me in the last couple of weeks about just a huge drop in NADAC reimbursement rates. And one of the issues is you have more and more states pushing for NADAC. You have some bills at a federal level that are potentially considering requiring NADAC for Medicare Part D. NADAC, again, is National Average Drug Acquisition Cost. It is for multi-source generics, and pharmacies are becoming increasingly required to report their acquisition cost prices to this accounting firm, Myers and Stauffer, that's contracted to calculate these NADAC prices. Now, what has allegedly happened is there was apparently a large chain that had not been reporting their acquisition costs that all of a sudden did. And they bought much more aggressively and competitively than a lot of the other people in the marketplace. So what did that do? Once they reported their acquisition cost prices, it dropped the whole the whole NADAC prices. That's been something that we've seen. So if you are looking at contracts that are cost plus, if you're looking at contracts that are potentially impacted by NADAC, it may not be explicitly impacted by NADAC, but if, for example, they say we're going to set our MAC prices based on NADAC, among other metrics of how we're going to calculate it, that's code for whatever independent research we do about acquisition costs. If NADAC is lower, we're just going to go with NADAC as our MAC price, okay? So if you're looking at a framework that's potentially taking into account NADAC, you need to be focused on dispensing fees. Dispensing fees, if you're being reimbursed at your actual cost, the only way that you're going to be able to keep the lights on is if you have key dispensing fees. So that's one of the things where people are getting contracts now, they're looking at them. That's a big area of focus that we're working with clients on to talk through them. Another concept that has come up a lot is these concepts of copay accumulators, copay maximizers, and other types of alternate funding programs. So copay accumulator, these essentially work where a commercial insurer will track the amount of money that's been paid towards the patient's copay that was funded by a manufacturer copay coupon program. You know, one of the BIN PCN group number cards that get processed as a secondary claim, if that gets processed and pays for a portion of the patient's copay, that portion that's paid by the manufacturer won't count towards the patient's deductible. One of the problems is a lot of plans found that patients would exhaust the manufacturer assistance, but they'd still have a couple more months left of therapy for that particular year. And what would happen, they'd stop taking the medication once all of a sudden they got a $3,000 bill for their medication that they'd been on for the past 4 months. So to make things a little bit kind of easier, more like a PR save, they came up with these concepts of a maximizer. The way a maximizer works is effectively smooths out that disallowance of the copay across the year. So as opposed to a patient not paying anything for months 1, 2, 3, and 4, and then all of a sudden owing $3,000, instead the maximizer might work by saying the patient has to pay $150 every month throughout the course of the year, but any of the amount of money that they're getting from the manufacturer isn't counting towards their deductible. These are in the copay maximizer space. You have PBMs that are partnering with third parties. Prudent RX and Save on SP are two examples. There are several others. But essentially what they're doing is they are out there actively searching for manufacturer assistance that's available that could lower the patient's copay, and trying to get the most out of it, trying to literally redesign the benefits so that instead of, you know, if a patient would normally pay $100 a month, which would in copay, that would result in $1,200 a year. If that manufacturer has up to $12,000 a year in annual assistance, they're just going to change the copay for that particular drug for that patient to $1,000 a month to maximize the amount of savings that they can get from the manufacturer programs. A lot of times these third parties or administrators, they get a share of whatever the savings is. You know, that's how they pitch it to the health plans. They say, you do this, we're going to save you money, but we're going to get a share of it. Again, it's another one of these things. If you look at how much dollars for every claim go to these companies, this is another example. In both instances, they allow the payer to extract the full amount of the manufacturer's coupon savings programs. Now, one of the other concepts that we've seen is sometimes I call it the free drug program. Sometimes I've seen it called an alternative funding program. Essentially, the way it works is similar to a maximizer. You have these third-party companies that are actively searching for savings, for deals by the manufacturers. And they are trying to find not just the copays that are available, but free drug programs. You know, if you're a patient that doesn't have insurance, a lot of manufacturers will make available drug programs to get drugs to you for free or for low cost. In addition, there are third-party charities, patient assistance programs that are out there like PAN or Patient Assistance Foundation that will qualify patients based off of income, based on assets, based on other financial criteria means. So these companies will work with those patients to try to get them enrolled in these programs. Even though they otherwise have commercial health insurance, even though they otherwise are fully employed and working and have benefits, they're going to make it seem like they don't have insurance, apply for this assistance through these patient assistance programs or these free drug programs and see if they can't get them covered. And if they can, great, the plan doesn't pay anything. If they can't, they bring it back in and the plan does an override to cover the drug for the patient. These function by characterizing these products as not essential health benefits. That means that they're saying we don't view these as essential health benefits, even though they could be totally curative, even though they could be totally necessary. The plan is saying these are not essential health benefits, and therefore we're carving them out from coverage altogether and only doing overrides to bring them back in if we can't get them otherwise approved through these alternative funding programs. In all instances, they, at least in the short term, save plans money. The manufacturers stand to lose a whole lot of money, and a lot of manufacturers are in dire straits about this. You know, it's kind of all hands on deck, DEFCON 20, trying to figure out what to do with this. And at the end of the day, patients risk going over the financial cliff when the benefits from the manufacturers run out, or the manufacturers stop offering these programs altogether because it's financially inviable for them to do so. They risk kind of going over this financial cliff. So what do these look like? What do the different kind of examples look like? So without a copay maximizer, let's say a patient has a $1,000 copay. After month and a deductible of $1,000. Okay, so month one, patient has to pay $1,000 out of their $10,000 drug, so they pay $1,000. The manufacturer covers it through the copay coupon card, so patient pays nothing. Insurer pays $9,000. $1,000 is applied to the deductible. Now the patient has met their deductible. The rest of it, they don't have any copay, and the plan is paying the full amount. With a copay accumulator, now that $1,000 that was paid by the manufacturer doesn't count towards the deductible. So that means month one, manufacturer pays $1,000, but the patient still has a $1,000 deductible requirement. Same thing with month two, month three, month four, and so on, so that at the end of the year, the manufacturer, instead of paying $1,000, now has to pay $12,000. And here the plan has saved saved $11,000. They've reduced their costs from $119,000 to $108,000. Now, the difference between an accumulator and a maximizer is in that model, the patient's deductible was normally $1,000. But now that the maximizer has seen that this maximum manufacturer assistance over the course of the year is $24,000, they're leaving $12,000 on the table. They're saying, why are we only charging $1,000 a month to this patient? Let's charge the patient $2,000 a month so we can maximize the amount of savings that the manufacturer is willing to throw at us. Let's go and maximize it as much as possible. And so as a result, now the manufacturer ends up paying $24,000. The health plan has ended up saving another $12,000. And so it's one of these financial tools that a lot of these plans are beginning to use, and that's really becoming a bane in the existence for manufacturers. And unfortunately, a lot of pharmacies are stuck in the middle where they just want to provide care to the patient, but they're having to jump through these hoops, maybe participate in unique networks, maybe have patients fall off therapy because of some of these things. Definitely something to just kind of be mindful of. Like I mentioned before, the alternate funding programs, these are instances where the plan will carve out the drug altogether. They will, a lot of times when it gets carved out, it'll have to go to a free drug pharmacy. You know, a lot of times when the manufacturers provide the drugs for free, they don't just let any pharmacy fill it. They require it to go through a particular pharmacy. Not only does this mean that you might lose volume if you're trying to dispense it, you'll also lose control of that dispensing event. You may not be able to track how much the patient is getting, when they're getting it, whether they're taking it, because it's now another pharmacy that's filling it. What if it's a healthcare provider administered drug? Now you can't do buy and bill, you can't even do clear bagging. You now have to go and accept that drug from a separate pharmacy, creating separate issues around white bagging and concerns there. There are some legal issues associated with these programs. For one, it's my position that these violate the Affordable Care Act rules around essential health benefits, particularly in how the plans have to create their design and apply it. It may also result in taxable income to the employees, and there have been a couple of litigations, the Johnson & Johnson versus Savon SP and AbbVie versus Payer Matrix. These are two examples where drug manufacturers have come back and tried to challenge the activities of some of these companies that are essentially trying to get patients to masquerade as if they don't have insurance so that they can get the benefit of some of these altruistic programs designed by manufacturers. Kind of an offshoot of that is this concept where, in addition to trying to get savings through manufacturer-free drug programs, we've also had companies that have developed programs trying to get savings by getting the drugs from Canada, to import it from Canada at cheaper prices, bring it to America through so-called self-importation, and get it at a lower price through Canadian pharmacy. This, putting aside the issues of you losing the revenue and losing the control of that particular patient and the information on their fills, and the issues broadly about FDA requirements about importing drugs from Canada and some of the other kind of concerns there. There's also just administrative costs for you as providers to deal with this, because in order for a Canadian pharmacy to fill a prescription written by a U.S. physician, the Canadian pharmacy has to co-sign that prescription, or the Canadian physician has to co-sign that prescription, and there's a whole process that goes into it. And it's time-consuming, it requires involvement by the prescriber, it involves involvement by the pharmacy, and all for drugs that are coming in from Canada that you're not going to be able to have a meaningful ability to continue to fill that patient for. FDA guidance does suggest that this is technically illegal. It doesn't permit it, certainly on a broad scale. You know, it's one thing if you go to visit Canada and you come home with medication. It's another thing when you're actively having it shipped to you from a Canadian pharmacy. But from what we can see, this appears to be very, very low on the FDA's enforcement priorities list. And even though I think that there's technical violations, I just don't foresee there being enforcement by the FDA anytime soon. And this is coupled with the fact that more and more states are creating these Section 804 importation program plans, where essentially they as states are importing drugs from Canada through some of these joint programs with the FDA to bring in cheaper drugs to the state to try to save money. So I even though I think that there's problems with it from a legal standpoint, I just don't see there being a great degree of enforcement around this. Another concept that people should be very, very keen and mindful of, because I think that this is a harbinger of things to come, is in the biosimilar space. So CVS Caremark, they have developed and rolled out this very kind of novel and unique biosimilar strategy. They've launched a subsidiary called Cordavis. They are a generic drug and biosimilar manufacturer, and I put manufacturer in quotes because they're not making anything, they're just partnering with people that are making stuff. And they're focused on distributing so-called lower cost products. They partnered with Sandoz in late 2023 to produce and distribute a Humana biosimilar they call Hyrimoz. And in January 2024, they announced that AbbVie's Humira would be excluded from all formularies, and that Hyrimoz would be the only biosimilar covered on most of its formularies. So what does that mean? It means that you can no longer get coverage, direct coverage for any other Humira biosimilar or Humira except for the version that is made by CVS Caremark. So if you went back to that chart I did before, I almost have to add another layer to it. Now I have to add manufacturer to that chart, because now you have the PBM that is no longer just controlling the reimbursement rate, but they're also controlling the acquisition costs. They're creating the price, they're creating the acquisition costs, they're controlling both ends of it, the buy side and the sell side. What's even more interesting with that is they've also announced a co-branding relationship with AbbVie, where they're going to make the exact same version of Humira. It's literally going to be overruns of Humira that they're going to co-brand. It's going to be identical, and it's essentially going to be an authorized biologic, even though that's not a regulatory thing. You know, there's an authorized generic in the NDA, ANDA drug space, but there's not the concept of an authorized biologic in the biologic space. But essentially, they're creating the same thing. It's going to be co-branded and co-labeled between AbbVie and CVS's subsidiary. And the reason that I say that that's unique is it's going to be the same price as Humira, but instead of charging rebates to AbbVie to allow that product to go through, now that they're doing this co-licensing agreement, this co-branding agreement, they could just charge licensing fees. And so my wheels start turning in my mind. It's now this is another effort, whack-a-mole game to stay one step ahead of the regulators, stay one step ahead of the plans, stay one step ahead of others to get money from the manufacturer to the PBMs in a way that they don't have to report it as rebates, because more and more states are requiring rebate transparency. You have laws at a federal level that are beginning to require rebate transparency, but if they can say, hey, this isn't a rebate, this is just a licensing fee, I view it as a way to try to get around some of these requirements. Now, they're doing this right now with Humira, but I predict that we're going to start seeing this with other therapies as well. So it's important to kind of keep a lookout on and be mindful of that particular impact. Another concept that is related to all of this is prescription discount cards. So prescription discount cards are, in theory, a way for pharmacies to drive savings to a uninsured cash-paying patient without undermining their usual and customary price. Because again, usual and customary is the amount a cash-paying customer would pay at that pharmacy on that date of service for that drug, inclusive of all discounts, loss leaders, special customer discounts, etc. Right? But the idea is a pharmacy submits a claim to a third party using a BIN PCN group number. They get an adjudicated claim, and it says, here's your new lowered amount. This is the contracted amount under this program. Collect this from the patient. So now the pharmacy collects that from the patient. It's no longer a cash-paying claim. It is a third-party adjudicated claim. And so now they can say, hey, we didn't undermine our usual and customary. This isn't a cash-paying patient. This is a insurance patient. Now, how does that look on your claim response? What does it actually look like? So here, let's say the AWP is $100. The pharmacy's usual and customary is $105. They're adding a dispensing fee above AWP. Their acquisition cost, let's say, is $20. Here, when they adjudicate the claim response segment might say, okay, patient pay amount is $30. Insurance pay amount is -$5, so that the total approved amount is $25. And the net profit to the pharmacy is $5. They bought it for $20. The total approved amount is $25. They bought it for $20. The total approved amount is $25. So their net profit is $5. Here, the prescription discount card company makes $5. It's a negative reimbursement. That $5 is coming out of your reimbursements from other sources. They typically, prescription discount card companies, will process on other PBMs platforms because they don't necessarily have a direct arrangement with you. GoodRx might not have a direct contract with you, or Single Care might not have a direct contract with you. Instead, they process on other PBMs platforms, and through those PBMs, so if you looked at your Express Scripts contract, your Express Scripts 835 remittance file, if you looked at your remittance advice with CVS Caremark, you might see deductions, and they may correspond with these types of negative reimbursement, these types of fees that are being clawed back from your other normal reimbursements that you're getting from the PBMs. Where we've seen this take the next level step is over the past year or two, we've seen several major PBMs and insurance companies announce partnerships with prescription discount programs, where essentially they're saying, we think for certain drugs, our patients can pay even less than their existing copays by leveraging the rates that some of these other programs are getting. They've suggested that the rates that the prescription discount card companies are getting are steeper. The discounts that they're getting are steeper than the discounts the PBM is negotiating, which to me, it blows my mind that you have this industry that has long defended themselves as being A+ when it comes to driving discounts and negotiating rates with pharmacies, that they're now having to go and rely on these new companies to do basically their job, in my opinion. Kind of throws the whole industry on its head in some ways, but nevertheless, they've come out and they've said sometimes the rates are better under GoodRx than what we're able to get. Sometimes what we've even seen is PBMs will carve out generics altogether. In every therapy, the only covered drug is going to be a highly rebated, high-cost brand. All the generics won't be covered at all, but they're all going to automatically have one of these prescription discount cards applied. So rather than allow patients to receive claims denials for non-covered generics, they'll automatically convert the claims to a prescription discount card that will result in a patient out of pocket that's at or below what they normally would have gotten if the generic had been covered and had a benefit design. What happens at the patient level is effectively, because that fee is coming out and going back to the prescription discount card company, and certainly a percentage of that is going to the PBM that's administering it, it's effectively a copay clawback. I don't know if everyone remembers a couple years ago, some PBMs like Optum, they created these things where they would say everyone's paying $15 across the board, no matter what. On your generic, it's $15. Even if the total cost of the generic was $7, they'd still make the patient pay $15. And that difference, that $8 difference between the $7 price that the pharmacy was getting and the $15 the patient paid would be clawed back and sent to the PBM. A lot of states passed copay clawback legislation. Federal government passed copay clawback legislation. Copay clawbacks kind of went away, but now you have this new effective workaround where they're basically doing a similar thing. The other problem, too, is they are pulling rates from a lot of different PBMs. It's kind of an aggregation of rates, and so you might have Caremark trying to pull Express Scripts rates, and Express Scripts trying to pull Humana rates, all to try to get the lowest possible rate on every single one of those claims. So here, it's not always apparent to the pharmacy whether one of these things have happened. We've had clients come to us and say, all of a sudden we're seeing incredibly low reimbursement rates on this, and we don't know why, and we're actually having money taken out from our account. We don't know why. And it's not clear at the point of sale when you adjudicate the claim that it's not actually processing under your particular PBM's contract, that instead it's processing under one of these other prescription discount card networks. There's a way to do it by looking at the back end, looking at the network reimbursement ID, looking at some of these other components, but it's not one of those things that's necessarily readily apparent when you're adjudicating the claim. So again, something to kind of be mindful of, because there may be ways that you can opt out of some of these things. There may be ways that you can say you're not accepting it, and even ways that you could challenge it from a legal perspective as well. All right, any questions on reimbursement issues and some of these kind of alternate funding programs? All right. We do have a question. All right, very good.
I kind of want to start off a discussion because this has been fantastic. Thank you for this. All these tools, and then you haven't even talked about regulatory headaches yet. I mean, trying to get legislators to do the right thing.
Yeah. Mm-hmm.
But I do have a question relative to patient assistance. You touched on it in this last segment. Going forward, if you put your crystal ball in front of you, do you think the free drug programs are going to be around? Are they going to go away? And there's, the Inflation Reduction Act comes to mind to me. What are your thoughts about those programs?
So, in terms of whether those programs are going to be around for the long haul, I don't think that they will, because I think what's going to happen is you're going to see, from a purely practical perspective, manufacturers come up with workarounds. They're gonna be more stringent about their policies. I mean, we represent manufacturers too. We do some work with them, and so we see kind of their thinking. And I think what you're going to see is an industry move in a direction where they're not gonna make it so viable for these things to continue. We've already seen it with Humira and AbbVie, where they rewrote their program and started enforcing it, where if they noticed a maximizer was going into effect, they weren't giving coverage. So I think you're going to see some of that. And then I also think there's a couple other things that have kind of come out where there's another Johnson & Johnson case where Johnson & Johnson was actually sued by an employee. And the employee sued Johnson & Johnson as a plan sponsor, saying, you're not executing your fiduciary duty to us as employees. That you have an obligation to not just sign whoever Towers Watson tells you to sign with for a new PBM. You can't just keep going with the big three. You have to think about this in my interests, and you're not. And so this is, I think, really going to reshape how plan benefit design folks and employee benefit folks at large employers are kind of thinking about these things. It already has. And so what I think is going to happen is they're going to rethink some of these short-term nickel and dime savings opportunities because they don't want to get sued for pushing costs or making it difficult or breaching fiduciary duties owed to patients. So I think in the long term, I don't see these as being something that's around in 5 years, or certainly to the extent that it is now. I think I don't. And one last comment is I don't know that we've yet hit the peak of it, but if I'm looking in the crystal ball, I don't see it in 5 years. Thank you for the question, by the way. All right, so as we talked a lot about issues, problems, concerns, but I know everyone wants to figure out ways that they can address it. They want the tools. They want the ways that they can help themselves. So one of the first ones here is the Medicare Any Willing Provider Law. Again, this is a federal statute. It applies to Part D plans, Medicare Part D plans, and it says prescription drug plans shall permit the participation of any pharmacy that meets the terms and conditions under the plan. This is a federal statute. In turn, you have federal regulations. One, that a Part D plan must agree to have a standard contract with reasonable and relevant terms and conditions for participation, whereby any willing pharmacy may access the standard contract as a network pharmacy. So you have the law that says must meet the terms and conditions. Then you have the regulations that inserts the reasonable and relevant requirement, okay? And in addition, it says that CMS requires that each and every contract must specify with the first tier, downstream, and related entities that they must comply with federal laws, regulations, and CMS instructions. So what does this mean? That means that any contract between a Part D plan and a PBM, any contract between a PBM and a pharmacy, those contracts have to include, by regulation, they have to include a requirement that all the parties are going to abide by the law. So what does that mean? That means that law, that federal statute, and that regulation are now pulled into those contracts between you, the pharmacy, and the PBM by operation of this provision. Those PBMs have to include language that says we're going to abide by law, and by the way, that law is going to include a requirement that we abide by the Medicare Any Willing Provider Law and that we provide reasonable and relevant terms and conditions, because that's a requirement. Even goes one step further, where now you have guidance that many PBMs define as law that states that the Any Willing Provider requires Part D sponsors to offer reasonable and relevant reimbursement terms, not just terms and conditions, reimbursement terms on Part D drugs, and that offering pharmacies unreasonably low reimbursement terms for certain specialty drugs to subvert convenient access standards is not a reasonable term and condition. Okay, so this has formed the basis of many cases that we've had against PBMs. It is something that we've successfully litigated. It's a tool that is there. It's important to, when you're signing a contract, to check the boxes to make sure that it includes these requirements, because they're key requirements. At a state level, about a little over 30 states have some form of either an Any Willing Provider Law or an anti-mandatory mail order law. Unfortunately, there isn't as much history or kind of interpretation at a state level or reading into it that it requires a reasonable and relevant terms and conditions, but nevertheless it has been something that we've used successfully to help push pharmacies into networks, and something that when you're having discussions with payers, it's something to be able to kind of always keep in the background. You know, put a slide that when you're in the meeting, just leave it behind you that quotes your state's Any Willing Provider Law as you kind of sit down and talk through the contractual negotiation. Other laws that we've seen at a state level that provide assistance, there's a whole set of minimum reimbursement laws. These are laws that require PBMs to pay at or above a certain rate. For example, Delaware has a minimum floor reimbursement requirement that suggests that the reimbursement has to be at or above NADAC, National Average Drug Acquisition Cost. Others have anti-price discrimination laws. For example, Maryland says that a PBM can't pay you less than it's paying one of its affiliates. Others create methodologies to resolve pricing disputes and create benchmark prices and give ability to appeal below water acquisition cost prices. For example, New Jersey gives that ability, that if you're paid less than your acquisition cost, you have the ability to go and appeal that claim. Kind of similar to that, there's a lot of states that have maximum allowable cost or MAC price appeal frameworks. Arkansas's Act 900 was the one that went up to the Supreme Court in PCMA versus Rutledge, but there are others. Virginia's, for example, creates a process to go ahead and appeal MAC prices, and if you're successful, it requires that those MAC prices, those updated MAC prices, be applied to all similarly situated pharmacies. So one of the things that we encourage everyone to do is have at least a person that part of their responsibility is evaluating the ability to file MAC appeals and tracking them and following up with them. Another set of laws that we've seen are anti-patient steering laws. Some of these laws prohibit either impose fines if a PBM steers to a PBM-owned pharmacy, or otherwise outright prohibits it. Or sometimes, like for example in New Jersey, it's not necessarily a law that's written in the insurance context. It's not like an insurance requirement, but rather it's a board of pharmacy requirement. If Accredo is working with Express Scripts to direct prescriptions to Accredo could have board of pharmacy discipline. Put aside, being regulated by the insurance commissioner, it's literally, they could be brought up on board of pharmacy professional discipline. Finally, there's unfair competition laws. For example, Massachusetts has a very, very strong unfair competition law that affords for up to treble damages plus attorney's fees. And what's been interesting is this particular law, Chapter 93A, has been used as the operational law to weaponize Massachusetts's any willing provider law. So it's been found that if a PBM violates the any willing provider law, that's almost de facto evidence that they've engaged in unfair business practices or unfair competition. There's also the concept of patient rights. So a lot of these laws that we talked about, some of them are going to apply in the self-funded ERISA plans, but most of them are likely going to be preempted by ERISA. Some of these laws will have some applicability, some ability to be able to be leveraged, but some of them, like the any willing provider laws, like some of these requirements will be preempted by ERISA. So that means if you're dealing with a Pepsi employee or an Exxon employee that their plan is self-funded, you're not going to be able to leverage some of these laws. So what does that mean instead? There are other tools that may be able to be used. Does anyone know what a summary plan document is? Okay. So a summary plan document is basically the required by law contract and disclosures associated with any form of employee benefits. So if you have employee benefits, you can get a summary plan document. You can get that document as it relates to your 401k. You can get that document as it relates to other employee pension programs, but you can also get it as it relates to your employee health benefit programs. That document is going to include your rights, it's going to include the requirements, it's going to include the disclosures. So if you have a scenario where the PBM is using a alternate funding program or they're using a copay accumulator program and it's not disclosed in that document, they've just violated ERISA. If you have a right as a patient in that summary plan document to see providers or to get a certain level of care that you're not getting, that's a violation of ERISA, and you could use that. Now, there's a way that you can step into the shoes of that provider, a lot of times through a assignment of rights or assignment of benefits provision agreement with the patient. There's a case, Venasinic versus PricewaterhouseCoopers and Express Scripts. That case involved a hemophilia patient that was being in Florida, where there isn't a robust any willing provider law, or at least wasn't at the time, where they were being directed to Accredo, Express Scripts wholly owned pharmacy, and the patient was complaining that they weren't getting viable care. The Accredo was missing doses, they were sending the wrong thing, patient was winding up in the ER with bleeds because they were a hemophilia patient, and they wanted to stick with their independent pharmacy that they were working with. In that case, the patient essentially sued their employer, PricewaterhouseCoopers and Express Scripts, alleging that they were not getting the care that was promised under their summary plan document, and a court agreed. The court and a motion to dismiss ruled in their favor and suggested that they could bring a claim for violation of their plan rights to be able to get care, and the result was they got an injunction that allowed them to get care from a independent pharmacy that they wanted to. That was their pharmacy of choice. So that's another option that's out there that we've worked with providers on. Another one, Doe v. CVS Pharmacy. This one has been, it was the Ninth Circuit. Parts of it have gone up to the Supreme Court. And essentially what that involved was CVS looking to do mandatory mail order for HIV patients. And HIV patients basically claimed that this was violating their rights under the Americans with Disabilities Act, the ADA, as well as the Rehabilitation Act. So even though these may have involved self-funded commercial plans that would have otherwise been governed by ERISA and state laws would have been preempted, nevertheless, they're still bound by federal rules like the ADA and the Rehabilitation Act, and they were able to show a disparate impact on them as HIV patients, which is a protected class. It constitutes a disability, and so there are a lot of other there are a lot of other disease states that can constitute disabilities. For example, cancer is another one. So these are things that create additional opportunities to be able to leverage some of these things. Now, a question that a lot of times comes up is do I have to go all the way to the Supreme Court to do this? The answer is no. No. These are things that when imbued into the discussion with some of the payers, when imbued into this, they can create an opportunity to get a little bit more leverage, to apply a little bit more pressure, and hopefully even get incremental change, incremental improvements. So I am going to I'm going to skip ahead to 340B issues because I know that's a big issue. We're running a little bit short on time. So 340B claim submission. So this is a big thing. When I talked about NCPDP before and I talked about reimbursement methodologies, one of the things that we've seen is there's a field, 420-DK. It allows you to do a submission clarification code. There's a lot of reasons that you would do a submission clarification code. You know, in the compounding space, you could do a code that would allow you to just get paid for the ingredients that are covered and not get paid for the other ingredients. In the 340B space, there's a code 20. That corresponds with this drug was purchased under the 340B program, or I'm dispensing this claim using drugs purchased under the 340B program. It indicates to the payer that this is a 340B claim. Several payers have begun to require this. They've begun to say, we want to know if it's a 340B claim, you tell us using this field. If you don't, it's subject to later recoupment or claims adjustment. One of the problems is you may not know at the time of at the point of sale whether that claim was in fact a 340B claim. Sometimes it's done retrospectively, sometimes it's qualified through the TPA after the fact. You may not necessarily know that it's 340B when you're dispensing it. Big question that I've gotten is, do I have to do this? Is there a legal requirement to do this? Now, there may be at a state level in certain Medicaid programs. Medicaid, there's a law on the books. You can't have duplicate discounts. There are different state requirements on how each Medicaid program is handling this to ensure that there aren't duplicate discounts. Some require it. Some require you to opt in or opt out on whether or not you're going to be using 340B as a whole. But it's unclear from a commercial standpoint what the real risks are associated with not doing it if you're being contractually required to do it. Now, why are they contractually requiring you to do that? Because they want to give you different pricing. They're not going to get the rebate from the manufacturer, in theory, on that drug if it's a 340B claim. So they want you to tell them it's a 340B claim so that in turn they're going to give you lower reimbursement. Maybe you would have normally gotten AWP minus 15%, but as soon as you identify that as a 340B claim, now they're paying you AWP minus 33%. Or some we've even seen where they're going to pay you your actual 340B acquisition cost plus a $10 dispensing fee. We have seen instances where PBMs have tried to claw back the difference, where they've paid at the normal reimbursement rates, later discovered that it was a 340B claim and tried to claw back the difference. Several states have begun introducing legislation prohibiting PBMs from imposing additional charges. About 24 states have this form of legislation. Several more are in the books, and essentially it's aiming to limit this form of pricing discrimination. At a federal level, there are a couple bills that are floating around that would seek to do this as well. Again, people have asked about the crystal ball on this. I think that we are not yet at the kind of critical inflection point on 340B. It's such the third rail politically that I just don't see anything meaningfully getting done yet. I don't think that it'll go on like this forever, but I just don't think we've quite reached that point yet, but we're getting close. One of the other areas that we've seen a lot is 340B litigation. This is disputes between contract pharmacies and covered entities, disputes between, so for example, if you're reconciling, you're saying that the contract pharmacy owes you money, or the contract pharmacy is saying you didn't provide the replenishment. Those are types of disputes that we've seen and have had to litigate in the past. We've also seen disputes between contract pharmacies and PBMs, where the PBM is saying that the contract pharmacy didn't buy the product, but the contract pharmacy did. It was just supplied through the covered entity. We've also seen litigation between PBMs and covered entities. And so how many folks use a contract pharmacy that is also owned by a PBM? That's a good amount. And when you're in that scenario, you have that contract pharmacy that has a contract with you to pass back reimbursement rates, but that contract pharmacy also has a contract with the PBM, and that PBM is themselves. So there's a lot of kind of manipulation, a lot of kind of reconciliation, reporting issues, passing through stuff that we've seen where we're working with a lot of health systems to kind of dig into that, figure out how they're being reimbursed and whether you're actually getting the appropriate amount. Because we've seen instances where the pharmacy, the entity-owned 340B pharmacy is getting reimbursement at one price, but when that same patient or that same drug or that same plan is being filled at the contract pharmacy, the amount being reported as the reimbursement rate that is being used to calculate the pharmacy dispensing fee, that's being used to calculate the TPA fee, that reimbursement rate is much lower, significantly lower. And there's a question as to why for that same patient are we getting a lower reimbursement rate when it's being filled by the PBM-owned pharmacy than when we fill it ourselves? And does that mean that the PBM is keeping the money? Does that mean that the specialty pharmacy is keeping the money? Does that mean someone else is keeping the money? Other litigation that we've seen, Pharma versus McLean. This is a case that is in the federal court in Arkansas, and it involves a law. The specific law is Arkansas Act 1103, the 340B Drug Pricing Non-Discrimination Act. And in addition to requiring non-discrimination as it relates to pricing, reimbursement rates by PBMs, it also sought to regulate manufacturers and sought to combat some of these manufacturer policies that said we're not going to sell to certain contract pharmacies, or we're not going to sell to contract pharmacies unless certain conditions are met. That law prohibited that type of conduct, required manufacturers to sell to all contract pharmacies of a covered entity. Pharma sued, trying to challenge that law, arguing that it was preempted by the FDA rules, arguing that it was preempted by 340B rules, and the Court of Appeals just came down and upheld the law and essentially found that the state could still regulate those aspects of it without it being preempted or overruled by federal law. So you have Arkansas has passed a law to that effect. About 5 states in total have passed some form of requirement on manufacturers not to discriminate in access by contract pharmacies. And there's actually a couple bills right now floating around at the federal level that would seek to do something similar. Also mentioned People of New York versus CVS. That was an effort by the New York Attorney General, Letitia James, to challenge the requirement that CVS said if you want to use our chain pharmacies as your contract pharmacies, you have to use WellPartner as the TPA. Fortunately, that case got dismissed. Letitia James refiled with an amended complaint. That amended complaint also got dismissed. So it was an effort by the regulators to actually take effort, but unfortunately didn't really go anywhere. Two other pieces of federal legislation. You have Novartis versus Johnson. This is a recent decision out of the D.C. Circuit Courts, where essentially the D.C. Circuit Courts upheld that a manufacturer could put into place certain restrictions on to whom they sold drugs under the 340B program. Essentially found that as long as they made an offer and made it available and it was able to be met, that it could be upheld. Right now there's one other case, Eli Lilly, that has been decided also, a similar decision. Right now there's a case in the 7th Circuit that is still up. The decision hasn't come down, and it could result in a circuit split because the lower court had held a little differently than the court in D.C. and the court in the 3rd Circuit, so we'll see what happens there. But that could create a circuit split where you have part of the country holding one way, part of the country holding another way, and that might wind up at the Supreme Court. Now this could be mooted if Congress actually does something, but we'll see. The last case I'll mention is Genesis Healthcare versus Becerra. So Genesis Healthcare versus Becerra, this is a case brought by a federal qualified health center that saw a very aggressive definition of patient. Essentially, their position was anyone that we've seen in the last 2 years that we've treated is a patient of ours. And as a result, regardless of whether we have filled that prescription, whether we have written that prescription, if any one of our contract pharmacies fills a prescription for that patient, at any time where we claim that patient as a patient of ours under the statutory definition of patient, we're going to claim them as an eligible patient and use 340B dollars, replenish, and get the 340B savings. HRSA came in and audited them, tried to kick them out of the program, rescinded that, tried to still audit them and claim that they were diverting 340B inventory. Ultimately, they sued and got an injunction from the court in South Carolina that basically said, no, the pharmacy could do this. HRSA was wrong in trying to do these things. The pharmacy's definition of patient is reasonable, and it's in line with the statute. So that means that there is a huge potential shift in how the industry looks at the eligible patient definition. Basically, theoretically, anyone that has been a patient of yours, regardless of whether you treated them for the condition that they're getting the prescription written for, regardless of whether your providers wrote for the prescription, regardless of whether you filled it, if they are a patient of yours, you might be able to claim them as a 340B eligible patient if they go to one of your contract pharmacies. Now, what is that going to mean? You could be a patient of one 340B provider and a patient of another 340B provider at the same time and have some other doctor write your prescription. And those two 340B providers might be contracted with the same contract pharmacy. Now you have a three-way battle between the two covered entities in the contract pharmacies over whose patient that is. I think that this is going to be the snowball that kind of gets bigger and bigger and bigger, because every day I get more calls from people trying to do different types of creative models to increase the 340B volume, and I think it's going to get to a tipping point at some point as a result of this. But for right now, it's a big question that we're fielding from a lot of systems and a lot of 340B covered entities is how do I rethink my patient eligibility definitions? How do I renegotiate my contracts with my contract pharmacies to make sure I'm not in this push-pull kind of fight with another covered entity over whose patient it is. I think it's going to be one of those things that's have to be rethought of by a lot of health systems. All right, so we have a little less than 10 minutes, and I'd like to get into our group project. So I am going to go right down to our group project. All right, so this is another one of these what would you do situations. What I'm trying to do is I'm trying to take some of the things we've talked about here and pull them into things that can be applied in the real world. So you open up your remittance advice hoping to see higher reimbursement rates now that DIR fees are gone, but you find that you're now being paid much less than your actual acquisition costs. You need to do something about this, otherwise you stand to lose millions of dollars over the course of the fiscal year by continuing to dispense at a loss. What are some of the questions that you would want to know to help determine what your options and next steps should be? What are the questions What are the facts? What are the variables that we need to know here to basically figure out what to do? Feel free to shout them out if you have any ideas. Sure. Check if the DIR fees from last year are still coming through. Sure. How about that very first slide? What type of insurance does the patient have? Do they have commercial insurance? Do they have Medicare Part D? Do they have Medicaid? How about who is the patient's employer? You know, who is the particular patient's employer? Is there an opportunity to communicate with them? Is the patient eligible for 340B? Is the reimbursement 340B specific? What does your contract say in terms of reimbursement terms? Does it say that you're getting paid that appropriate rate? Does it say you're getting paid, you know, a different contractual rate? Is it brand versus generic? There might be different options and rights that you could follow if it's a brand versus if it's a generic. Is the PBM actually reimbursing anything? Remember we talked about before that scenario where a pharmacy all of a sudden saw a huge drop in reimbursement rates, and it turned out the PBM wasn't paying anything. Instead, what happened was a prescription discount card was being utilized. Who else can fill the prescription? Is it a limited distribution drug? Are there other pharmacies in the network that could fill it? And if so, who? These are the types of questions that you want to be thinking about as you're encountering these things, because they're going to help drive what opportunities, what actions you have. Okay, so here are some additional facts. The patient has commercial insurance through their employer, so they're a commercially insured patient. They have an employer that they're getting insurance. It's not self-funded. It's insurance. Okay. The patient works for a small local company who buys insurance on behalf of its employees. The patient is 340B eligible, and it appears that the pharmacy is receiving 340B specific reimbursement rates. The contract indicates that the pharmacy will receive up to an average discount of AWP minus 25%, but the rates that you're getting for this patient appear to be much, much lower. It is a specialty brand medication, and the only other pharmacy provider in the network contracted with the plan that can provide this drug is the PBM-owned specialty pharmacy. And the PBM is reimbursing for this claim. It is not using a prescription discount program, okay? So those are the additional facts. So now is your instructions. Find your neighbor, introduce yourself, find the folks sitting near you, and talk about what you think the types of laws that might be implicated by the PBM's actions. Start to think about what agencies or other third parties you may be able to contact or complain to or reach out to about the PBM conduct, and get the ball rolling on developing an action plan to combat this underwater reimbursement. And in the meantime, if you haven't, or if you have, shot me an email about any additional questions. I'll be happy to take a look at those while you kind of talk amongst yourselves, and then we'll wrap it up with some final thoughts. All right?